Well, thanks, everyone. Just wanted to correct the record here. Rick said I'm with the UF Levin College of Law. I'm actually recently retired from the UF Levin College of Law. And as you can see, I'm failing miserably at that. But this was a great opportunity. Like Robert, I've been involved for 2.5 decades at least, maybe a little bit more, with boating issues in the state. And I'll talk a little bit about how that came about. But first I want to introduce our other speakers here, and for that I have to show their, as if you don't see them enough, they're here too in their suits.
I forgot my suit today, guys.
What's great is that there's a future for the folks that are passionate about boating law and the issues around the marine and coastal environment, and I'm real happy to have these guys come along with me and help me find my way to retirement, at least at some distant future. Brendan Mackesey is the assistant county attorney of Pinellas County, which is a peninsula on a peninsula, of course. So very much engaged in the marine and coastal issues in the state. He presented various webinars and talks on resiliency, coastal regulation, and derelict vessels. He and Byron had put together something for attorneys on derelict vessels, and I'm sure you'll be hearing more about that a bit later, at least in sidebar conversations. He was involved with the University of Miami Law Review. He's published articles in the Florida Bar Journal. He's on the executive council of the Florida Bar Environmental and Land Use Law section. And finally, and he's forced me to say that, he's a proud triple Miami Hurricane.
Sorry, guys. I know we're in Seminole territory up here, but I got to hold up the year.
That's Brendan. Byron Flagg is a colleague of mine and friend from goes way back, lives in Gainesville. He's currently with the Gray Robinson Law Firm, helping to support this workshop. In his capacity, he does a whole lot of things in that capacity, working with individuals, local governments, land use, zoning. He's always, though, maintained this interest in the water and boating and navigation issues. He's a veteran of the United States Coast Guard. That sort of tells you everything you need to know. He also served as a attorney with the St. Johns River Water Management District, so a real diverse background there. What I'm going to do now is go back here. So this is a publication that has kind of tracked the stem to stern as it's gone along. That kind of started my career with Florida Sea Grant. That first one on the left, back in August 1999, we probably started working on the issues several years before that. It's been, I believe, sort of a go-to document for particularly for attorneys, but also for local government folks, and trying to understand the legal framework that sits on top of the water, which is so different from what sits on top of the land. There's been 5 editions, which tracks the career of Robert and myself and others perhaps in the room. And we're going to publish a 6th next year with support from Florida Sea Grant. And these 2 gentlemen will be my co-authors, and then they're going to take it over and I will sail away. So just briefly, all of this issues of anchoring and mooring, which is what we'll be talking about today, goes way back in Florida history to the 90s and probably before, but over in Southwest Florida from Tampa south, disputes over how long you can be at anchor, the length of stay. And local governments right down the coast from Tampa Bay down were regulating the anchoring differently, each one. Some had 1-day length of stay, some had 2-day, some had 3-day, some had 5-day. It was creating a lot of confusion. The boating community was upset about it. These were they call them transient boaters, people who were just moving down the coast and enjoying the water bodies and getting sort of conflated with liveaboards and so forth. An anthropologist from the University of Florida, Gus Antonini, sort of took this on as a project, looking at the culture of the boating community and so forth, and was a boater himself. So he ended up, if I have it here, he ended up writing, oops, I'll just do it back. Sorry about that. That little publication there, Guide to the Anchorages of Southwest Florida. Suddenly people thought these were official anchorages. They never were. And that caused a lot of interest to develop. And with that interest, this interest in local governments being able to, I wonder if I'm stepping on something, if local governments being able to regulate. The state has consistently held that this is the province of the state of Florida to regulate how long people can stay on the water. Navigation is a public trust right under our doctrine. And it also kind of goes back to this legacy of the freedom of the seas. It's a long and interesting story. It's evolved to the point, which is where we're going to take it here, where there was efforts by individuals, wealthy homeowners and that sort of thing to get anchorage limitations put into specific canal areas in South Florida, for example. And they were going through the legislature. They were bypassing the folks in the room here, the administrative process and the local government process. That led in turn to an effort to get a handle on this at a statewide basis, and that's why we have this concept called anchorage limitation areas now. Another thing that was occurring throughout this period of time was the growing interest in mooring fields, and the hope that mooring fields would be an alternative to informal anchoring that people would embrace. But of course, there's two different communities of boaters out there. And that was not the case. FWC had a pilot program that lasted 8 years, I think, and some communities participated in it, but it didn't materialize into legislation until just recently. We now have this concept of an anchorage limitation area that local governments can apply to FWC for justify and then get some handle on length of stay. Ultimately, it's a land use issue, even though it's on the water. I think that's how the local government folks would look at that with these sorts of things. So that's sort of the origin story. Let me back up just a second. So what we're going to do here is Brendan's going to go first. He's going to talk about this concept of state preemption, why the local governments don't have the authority to regulate length of stay on the water. The anchorage limitation areas that I just talked about, floating structures, which have also become an issue. They can't get underway. They sit there, they sell things and that sort of thing. They become a local government issue. Boating aggregations. I know you have these up here. There's an FWC captain. I don't remember which one it was. One of the STEM terms that coined this term, kind of like spawning aggregations, where boaters come all together from all over and enjoy the water. And that can be fun. It can also be a problem. Interlocal cooperation, because anchorage limitation areas are limited to the counties, you have to be able to negotiate and cooperate with the municipalities who sometimes have that water-based jurisdiction. And then Byron's going to take it over and talk about boating restricted areas more broadly, and this concept of how and when you can restrict how boating happens on the shore. So with that in mind, I'm going to leave you with a question. We're not going to answer it yet, but and it's a little bit something wonky about it, but it's the existential question of the day: is this vessel in navigation? So the term in navigation is a term that's deep in meaning in both international, federal, and state law. And I want you to think about that up until Byron finishes his talk, and then we'll ask you to answer that question for us. Okay, so it's up to you. I'm not sure why this thing is flittering, but we're trying to work on it. Okay.
And while my presentation is brought up, I'll just say good morning to everyone. It's a pleasure to be here. As Tom mentioned, I've gotten to know he and Byron through various professional organizations over the years, mostly involving vessels, but not always. And it's a true privilege for me to be here before you all today, especially part of the state that I've never been to before. So it's very cool.
We're setting up again. If you got questions, you can talk on the card.
Yeah, and also Tom already touched on this, but just to briefly walk through what I intend to talk to today. I'm going to start with a very brief overview of the state regulatory scheme and how preemption fits into that. Let me get into in a little bit more detail what anchoring limitation areas are, what Pinellas County specifically has done as far as adopting two of those areas recently. From there, I'm going to take into floating structures. I've got a pretty cool case study on a floating tiki bar that's now moved over to Hillsborough County and is called Beer Can Island that I'll talk to you guys about. And then, of course, we'll discuss the boating aggregate areas a little bit. And finally, if time permitting, I'd like to talk just very briefly about some of the avenues available for interlocal cooperation, which as a local government attorney, I find to be very important.
Thank you for your patience, everyone.
Yeah, of course. I see it.
Yes.
You want to stand by the podium, please go ahead and do your.
I had the forces.
I take it I'm just using the arrows to
That's what I do.
scroll through. Perfect. So here's that outline I just gave a minute ago. Okay, so local vessel anchoring generally, the word that comes to mind is preemption. So what is preemption? It is essentially a higher authority telling you that you can't do something. And generally speaking, with the exception of liveaboards, non-fishing commercial vessels and public mooring fields, local governments are heavily preempted from vessel anchoring. There is a caveat to that, which I'm going to talk about in a minute, anchoring limitation areas. Now, general law, as you see before you, general law is really just the Florida statutes, does prescribe certain anchoring and mooring limitations. Some of these are obvious. You can't moor up to a uniform waterway marker, right? But others aren't quite as obvious, like not being able to moor within 100 feet of a public mooring field, actually a lesser distance if FWC allows it. And then another new law that was just adopted over a year ago, mooring to any unpermitted object automatically makes that vessel at risk of becoming derelict. And the real significance there is that 3 of those citations within 18 months allows that vessel to be declared a public nuisance, which of course triggers the derelict vessel removal process that we heard referenced in the panel before. And finally, I don't want to dwell on this here, but it's important to be aware of the submerged lands on where you're operating and regulating. Sovereign submerged lands are, you got to look at them a little bit differently than privately submerged lands. But again, that's a different topic for a different day. So what are some of the general concerns with liveaboards in particular and stored vessels, at least from my personal subjective mindset in Pinellas County? And I bring up liveaboards and stored vessels particularly because these were the impetus for us adopting the anchoring limitation area ordinances that we did just a few weeks ago. So we all know that they're an impediment to navigation. We all know that they're an aesthetic blight, but I think and we all know that liveaboards, of course, are prone to dump their sewage over water, and that can be very hard to catch. But there's a few less obvious impacts that I saw touring the waterways not too long ago that I think folks should be cognizant of. I toured an area that was full of liveaboards, and a pit bull almost jumped across the boat and got me. I felt like you see a lot of dogs on these boats, and not only am I concerned for the welfare of mariners sailing nearby, but I'm concerned about the animals, right? You know, who's watching these dogs, who's feeding them? You know, if they go to the bathroom, are their feces just being dumped over water? I mean, these are some of the less obvious things that people don't think about. Also in Pinellas, I know that we get lots of complaints and concerns about burglary. These liveaboards in particular tend to congregate in particular areas, scout out the areas, and burglarize boats nearby. The hope, at least, is that deterring prolonged anchoring in some of these specific areas might, you know, bring some of these issues down a little bit, but that's obviously not guaranteed. And then thinking at a more macro level, when we think about liveaboards and stored vessels, think about property values. You've got a multi-million-dollar mansion on the water, but you've got a bunch of vessels anchored just outside of it. If there are some realtors in the room, I'm sure they would tell you that arguably that's bringing down the value of your home. And then if you really want to think at a macro level, in Pinellas County, we're relying on tourism for just about everything, right? Tourists come to our county to enjoy our beaches, enjoy our waterways. They see these liveaboards and stored vessels everywhere. Perhaps it's a deterrent for them coming back. So what are some basics on anchoring limitation areas? Well, they're right before you. As Tom mentioned, only counties can adopt them. In addition, it's unlawful for any, the crux of this is that a vessel cannot anchor for over 45 consecutive days within 6 months. The vessel operator must prove that he or she traveled at least 1 mile away. And curiously, each ALA must be adjacent to an urban area with residential docking facilities and significant recreational boating traffic. And obviously that's very broad, not an issue for a county like Pinellas, which by its nature is very urban, but could be an issue for other more rural areas. In addition, I know I already got a question about this morning. Each ALA cannot exceed 100 acres in size. And they cannot exceed 10% of a county's navigable, in fact, waterways. As far as enforcement goes, the kicker is that if you get 3 citations within 12 months, and again, think about this, that's hard, right? They've got to be there 45 consecutive days. So nailing them 3 times within 12 months, you really got to be on top of that vessel, and that vessel operator, it's got to be pretty foolish. That allows that vessel to be categorized as a public nuisance, triggering essentially the derelict removal process. Not too much different than the at-risk process that some of you are familiar with, whereby if you get 3 citations for being at risk within 18 months, you can be treated like a derelict vessel and removed from the water. So that sounds simple enough, but there's some real concerns with this statute. First of all, if anyone can figure out why the legislature decided to stick that within 6 months in the statute when they're saying that you already can't be there for 45 consecutive days, let me know, because I can't figure it out. It would have made sense if they said 45 days within 6 months, but they didn't. 45 consecutive days within 6 months. So go figure. Additionally, they've really put the onus on the vessel operator to prove that he was 1 mile away. That's kind of backward logic, in my opinion. So essentially, law enforcement has to give the vessel operator a chance to prove that he or she was 1 mile away. And if he or she can't do that, then that's when a citation is appropriate. Typically, a statute would say something along the lines of, the vessel must travel 1 mile away, or it's violated, the provisions of the 45-day requirement. See here. And then moving on to enforcement, I think, in speaking with some of our local law enforcement officers, there's a real concern that, impounding a vessel for 48 hours might just not be worth it. The way the statute reads is that essentially, if you cite a vessel for being within an ALA and they don't leave, they can be impounded, that vessel can be impounded for 48 hours. Now, the statute says that, the owner's responsible for all the removal and storage fees and what have you, but it also says that vessel needs to be removed after 48 hours. So it's not entirely clear whether the impoundment facility and law enforcement, so to speak, can keep that vessel at that impound facility there for longer than 48 hours until those fees are paid. Again, these are some concerns that were brought to me by our local law enforcement agency. And so I think, kind of the biggest takeaway here is that while it's relatively easy to draft one of these ordinances, creating one of these areas and, apply to FWC for your signs and markers and put them up there, there's a lot of concerns with enforcement and how well this is going to work in practice. So what have we done in Pinellas? Let me start with this. I believe Broward was the first county to adopt anchoring limitation areas. They did so in the city of Hollywood. We recently we became the second county, I guess. And we adopted two, one of which you can see is incorporated Clearwater. Remember what Tom mentioned earlier. Only counties can adopt anchoring limitation areas, not cities. So Clearwater came to us and basically asked us to adopt this area. Could we have been petty and said no? I guess, sure, we wouldn't do that. Of course, we want to be good neighbors with our cities. But what we did do is we essentially delegated a lot of the responsibility for enforcement and implementation of the anchoring limitation area down to Clearwater via an interlocal agreement. So the county tried to essentially wash its hands. Now, as the adopting entity for FWC, we've got to be the permittee. So we're not off the hook from liability. You know, if a jet skier or someone runs into a sign marking the entity, we very well still could be sued, but we loaded up that interlocal agreement with at least within the confines of the Florida statutes with all sorts of liability protection for the county, really passing the buck to Clearwater here. Another ALA that we just adopted, and again, when I say just, I literally mean just. I got the state filed ordinance back from Tallahassee a week ago. So if you guys visit our lovely county, you won't see these marked quite yet. We're working on getting those markers, but this one's a little bit smaller. It's in unincorporated, and it's really it's targeting stored vessels. And there's not that many of them, to tell you the truth, but they do tend to appear recurrently. It's a smaller area. And it's right off the ICW, so it should be easy for law enforcement to monitor. What's interesting here, I think, is the real concern. Obvious, you know, we know that people that live around here don't want to look at the boats and navigate around them. We get that. But the real concern from the county standpoint is that we've had a lot of storms in Pinellas lately, and some of these boats are prone to washing ashore and damaging mangroves, upland vegetation, even infrastructure. There's a major causeway right there, the Bel Air Causeway, for those of you who are familiar with the county. And occasionally these boats, not all of which are in poor condition, can wash ashore and, you know, pose a real safety threat. And I don't think that, public concern should be overlooked when these anchoring limitation areas are explored. Okay, thank you. Moving on to floating structures, just very quickly, local governments can regulate them. You heard Tom mention that earlier. I won't get into the definitions too much other than to say that, you know, if its primary purpose is not transportation, but rather what otherwise would be, you know, best categorized as an upland use, there's ways to attack them. I've seen it done via zoning regulation. In Pinellas County, we have a very broad prohibition that prohibits developed uses over natural waters that we've used, not just to address, say, restaurants over a pier, but also a floating structure, which I'm going to talk about on the next slide. Right here, this floating bar that you see. Now, these guys got in trouble, not just with us, but with the Coast Guard as well. And I'm assuming we've got some folks from the Coast Guard here, but they required a certificate of inspection, which got them into some hot water. But we went after them for this provision right here. That's all it took. We don't have a specific ordinance to floating structures or anything like that, although I know that certain counties do. I think it's St. John's that comes to mind, Flagler also. But in any event, we sent them an NOV and they went on their merry way. And where did they go? For those of you familiar with the Tampa Bay area, Beer Can Island. They bought a spoil island for $60,000, posted up shop there. They're throwing concerts, renting it out for weddings, parties, you name it. And you can see all the boats there. But where's all the first responders and how are they going to get there? Think about that. But in any event, this issue is still going on. This is outside of my county. But Hillsborough code enforcement went after them, tried to bust them. But because the island is unzoned, the code enforcement board had no standards to hold them to. So the code enforcement board said, we don't know what to do with these guys. They can essentially just enjoy their spoil island. So they're still there. The party's still going on. And as we speak, the Hillsborough County Commission is grappling with a land use designation for this island, which is going to be controversial. However, it ends up and could very well possibly lead to litigation down the line from the owners if they can't use their island as they, envisioned that they could when they purchased it. And that's a good segue into these boating aggregate areas. I mean, I think that the concerns with them really speak for themselves. You can see them, a lot of them listed up here. One interesting case study I want to point out to you all from Pinellas County. This is Outback Key down in Fort DeSoto Park, probably our most popular park. This is a shoal that formed, I don't want to trip over that formed offshore over sovereign submerged land. What's
You can trip right into fire.
I could. And so, what started as a shoal over sovereign submerged land has now suddenly connected with a county park. Right? Well, who's responsible for that? Not to get into what accretions are and avulsions are and that sort of thing. But, the party rages on that boating aggregate area Outback Key. And it's not quite clear whether it's now part of the county park because it's connected or whether, it's still sovereign submersion. I think that's an interesting legal question. But in any event, the concerns with these boating aggregate areas, you see a lot of them posted before you. The most, I think the most inobvious one that I see come up all the time is some of the impacts to habitats. This is a very common shorebird nesting area, sea turtles too. Obviously, we know these boats are a nuisance. We know there's drinking, partying going on and whatnot, but a lot of people don't think how it might affect the local animals and habitats in the area. Wrapping up, guys, I promise, very briefly, you heard me talk about interlocal cooperation in the context of anchoring limitation areas earlier. I just want to make sure that you all know that these paths are out there. Annexation, very interesting. I encountered a situation not all that long ago where a city in my county was seeking to annex unincorporated submerged lands. Well, I didn't know how the heck to do that. So I did what anyone does. I hopped on Google, I started researching, and sure enough, I found out that I believe it was the city of Bradenton Beach had successfully gone to the state legislature to accomplish it. I think that's in Manatee County, if I'm not mistaken, just south of me. And so that, yep, that was to do a mooring field. So the takeaway is that it's possible. Don't think that submerged lands can't be annexed because they can. And then I read a wonderful memo authored by these two gentlemen before you that brought up another example in Fernandina Beach, I believe, where the voluntary annexation process under 171 was utilized, and the state simply approached the city. The city adopted an ordinance, and it was done that simply. So for those of you with cities out there looking to expand your jurisdictions for mooring fields, regulating liveaboards and otherwise, there's ways to do that. And I certainly don't need to talk about transfer of powers here, but interlocal agreements are always a great option, but annexations are an option too. Last slide from me. I'll just say this: know whether you're in a charter county or a non-charter county. Very different. Charter counties can adopt ordinances that preempt municipal ordinances. So for those of you with cities that adopt, ordinances concerning, it could be a mooring field, it could regard liveaboard vessels, who knows? If you're in a charter county and your it's listed in the charter as a charter power to regulate vessels, and the charter passes a more restrictive conflicting ordinance, you are preempted. So very important to know that. Again, defer to your local attorney. Certainly they can tell you more about that, but I was pretty surprised doing this research. Certainly I thought we'd have more charter counties in the state of Florida, but many of our smaller charter counties, or pardon me, smaller counties simply don't have charters. Although if there's any interest in creating a charter, there's a way to do it. You just got to create a charter. What are they called? Just charter commissions, I believe, and you got to hold a referendum. But in any event, that's all I got. I'll be around if anyone has questions at the end, and I will turn it over to Byron, but I know we got to get his presentation up and loaded, so. Yep.
Yeah, while that's loaded up, if you got questions, you can put them on the card and address them to Brandon today, so when at the end, we can make sure the question is.